There are certain Supreme Court cases that are infamous, either for their import or their error. Miranda, Roe v. Wade, and Obergefell are just a few. Two of these cases are known simply as Dred Scot and Korematsu. These cases are not only examples of when the courts get things wrong, but of our nature to treat others as less than human. So we'll look at these cases next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Welcome to the Constitution Study. This is where we read and study the Constitution, teach a rising generation to be free. I'm glad you could join me today. These are a couple of interesting cases. I think you'll find them useful. But before we get into that, please check out the website, constitutionstudy.com. I'm still looking for venues for my Blessings of Liberty tour. I'm still looking to people to join us on our Constitution Study online, and there's so much more. Just check it out at constitutionstudy.com, and I'll talk a bit more about that at the end of the episode, but for now, let's take a look at these two court cases. In the Declaration of Independence, Thomas Jefferson gave us this iconic phrase: "We hold these truths to be self-evident, that all men are created equal." Sadly, we have yet to live up to Jefferson's vision. We have a history in America of treating certain people as less than human. Now, we hear a lot about the enslavement of blacks and some about the treatment of Indians, but little about how the Chinese, the Irish, the Italians, the Jews, and others have been treated. You would hope that, at least before the court, justice would remain blind. Two cases we're looking at today show that injustice before the bench is nothing new. Now, most Americans have at least a passing familiarity with the Dred Scot case. Most of us were taught in schools that this is a case where the court found that blacks were not citizens and had no rights. A free Negro of the African race, whose ancestors were brought to this country and sold as slaves, is not a citizen within the meaning of the Constitution of the United States. Now, are the rights protected by the Constitution limited to citizens of the United States? Well, Article 4, Section 2, Clause 1 of the Constitution says, "The citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states." While there are privileges and immunities, such as voting, that are limited to citizens, other rights protected by the Constitution aren't. For example, the Fifth Amendment states, "No person shall be deprived of life, liberty, or property without due process of law." The issue at hand did not rest solely on Mr. Scott's race, but on his immigration status. Reading from the opinion: "A state, by its laws passed since the adoption of the Constitution, may put a foreigner or any other description of person upon a footing with its own citizens as to all the rights and privileges enjoyed by them within its dominion and by its laws. But that will not make him a citizen of the United States, nor entitle him to sue in its courts, nor to any other privilege and immunities of a citizen in another state." Remember, this was 1856, before the 13th and 14th Amendments were ratified. When Mr. Scott's ancestors were imported as slaves, they were not granted citizenship. As such, Mr. Scott was not considered a citizen either. He was, however, a person, and should have had his liberty protected under the Fifth Amendment. That was not the case. Now, this precedent was overturned by the ratification of the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, most people I talk to don't recognize the case Korematsu versus United States, even though they are aware of the Japanese internment during World War II. It all started when President Roosevelt signed Executive Order 9066. "Now, therefore, by virtue of the authority vested in me as President of the United States and Commander-in-Chief of the Army and Navy, I hereby authorize and direct the Secretary of War and the military commanders who he may from time to time designate, whenever he or any designated commander deems such action necessary or desirable, to prescribe military areas in such places and of such extent as he or the appropriate military commander may determine, from which any or all persons may be excluded, and with respect to which the right of any person to enter, remain in, or leave shall be subject to whatever restrictions the Secretary of War or the appropriate military commander may impose in his discretion." Let's start with the obvious. There is no authority vested in the President of the United States to designate military areas within the United States. Article 1, Section 8, Clause 7 delegates to Congress legislative power over federal property, including places purchased by the consent of the state legislature. Quoting, to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may, by secession of particular states and the acceptance of Congress, become the seat of government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Not only did this executive order claim powers not delegated to the United States, much less the President, it violated both the 5th and 10th Amendments of the Constitution. See, the 5th Amendment states, "No person shall be deprived of life, liberty, or property without due process of law." And the 10th Amendment says, "The powers not delegated to the United States by the Constitution, nor prohibited by the states, are reserved to the states respectively, or to the people." This means that Executive Order 9066 is not only invalid, but void. Well, at least according to Alexander Hamilton in Federalist Papers 78. There is no position which depends on clearer principle than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. Yet, just like today, that did not stop those in government from treating this illegal order as valid law. In response to President Roosevelt's order, the Western Defense Command and Fourth Army issued the Civilian Exclusion Order No. 34. Pursuant to the provisions of Public Proclamations No. 1 and 2, this headquarters, dated March 2, 1942, and March 16, 1942, respectively, it is hereby ordered that from and after 12 o'clock noon PWT of Saturday, May 9, 1942, all persons of Japanese ancestry, both alien and non-alien, be excluded from that portion of Military Area No. 1 described as follows. Under the Uniform Code of Military Justice, members of the military are required to follow all lawful orders. Since the President does not have the authority to designate areas as under military control, he cannot legally order someone to do so. Furthermore, Lieutenant General J.I. DeWitt, commander of the Fourth Army, violated both his oath and the law by depriving people of their liberty and property by excluding people of Japanese ancestry from any area. Civil Exclusion Order No. 34 also required a member of each family report to a civil control station, again, in violation of the Constitution and laws of the United States. A responsible member of each family and each individual living alone in the above described area will report between the hours of 8 a.m. and 5 p.m. Monday, May 4, 1942, or during the same hours on Tuesday, to the Civil Control Station located at 920 C Street, Hayward, California. Now, those who reported and their families would be relocated to internment camps for the duration of the war. Dred Korematsu ignored the order to relocate, was arrested, and convicted of violating the order. He sued, arguing that the executive order infringed on his liberty without due process of law and therefore violated his rights protected under the Fifth Amendment. Sadly, the Supreme Court did not see it that way. We uphold the exclusion order as of the time it was made and when the petitioner violated it. In doing so, we are not unmindful of the hardships imposed by it upon a large group of American citizens. But hardships are part of war, and war is an aggregation of hardships. All citizens alike, both in and out of uniform, feel the impact of war in greater or lesser measure. Citizenship has its responsibilities as well as its privileges, and in time of war, the burden is always heavier. Compulsory exclusion of large groups of citizens from their homes, except under circumstances of direst emergency and peril, is inconsistent with our basic governmental institutions. But when, under conditions of modern warfare, our shores are threatened by hostile forces, the power to protect must be commensurate with the threatened danger. So, according to the Supreme Court, you have no rights except the ones government allows you to keep. The court talks about the hardships of war, but seems to ignore the Constitution of the United States or the concept of unalienable rights. This case is an example of the abuse of so-called judicial review, the idea that the courts can supersede your rights and the Constitution when there's a sufficiently compelling government interest. If the government doesn't need to follow the supreme law of the land, then what good is it? What were these brave men fighting for, if not to protect the rights this government had denied to people based solely on their heritage? How can you expect your rights to be protected by such a so-called justice system? Now, what do these two famous, or rather infamous cases have in common? They denied rights to human beings because of their ancestry. While the precedent set in Scott was overturned by the 14th Amendment, nothing has overturned the opinion in Korematsu. Laws that violated the supreme law of the land were used in both cases, and courts endorse these travesties of justice. Santayana said, "Those who cannot remember the past are condemned to repeat it. There is nothing we can do to change the past. However, by remembering the past, we can learn from it and do whatever we can to prevent similar abuses from happening in the future. Yet here we are, watching while government officials pass repugnant laws and issuing illegal executive orders to infringe on the rights of the American people. People are denied their liberty and property for not complying with an illegal government order. People are being denied their right to speak and to the press if they contradict the approved government narrative. Roosevelt's executive order led to exclusion and internment, and Biden's orders have led to banishment from employment, public transportation, and health care. Let us not forget about the internment of those who challenged the validity of the 2020 elections. I wonder if future generations will look back at the laws and cases we're dealing with today with the same disdain with which we hold these two cases. Dred Scot and Korematsu. Two cases that show courts are not always right. Two examples of why courts do not rule, they opine. Why courts are subject to the Constitution, not arbiters of it. Why government must be subject to the supreme law of the land, because if not, they will find any excuse they can to infringe your rights. Now, hopefully you've learned a little bit from this episode and you'll share it with others. Please head to constitutionstudy.com. You'll find the article and the video that you can read and you can share absolutely free. Please do so. Share it with friends, share it with family, share it on social media. Help others to find the Constitution study and the information that we bring here. Now, if you'd like me to come speak in your area, just go to constitutionstudy.com/tour, fill out the form at the bottom, and I'll reach out and we can find out if we can make that happen. I'm looking for as many venues as possible throughout these United States to help us secure those blessings of liberty, not just for ourselves, but for our posterity. But I need your help. Whether it's you're hosting an event or attending an event or just letting people know about these events, these are all ways you can help. And if you can help financially, there's a donate page right there on the website as well. So I hope you found this useful. I hope you shared it with friends and family. And I hope you'll all join me here next time for the Constitution Study.
There's one thing you have to